The U.S. Supreme Court last week ruled that a Colorado website designer could refuse to do business with a same-sex couple. The case had been framed as a clash between free speech rights and non-discrimination rules. Well, now there's a twist. LGBTQ advocates are raising questions, suggesting the court should never have taken the case. WATE 6 on your side legal expert Greg Isaacs joins us now to talk about that. Thank you for being here.
Lori, it's great to be here.
We've been talking about this on the newscast. There are doubts now about whether the designer was actually asked to make a website that might violate her beliefs. Explain what's going on here.
Wow, a controversy within a swirl of controversy regarding this latest ruling. And it's like a deja vu all over again. 5 years earlier, another Colorado case in Masterpiece Cake, the Supreme Court ruled that a baker could refuse making a cake for a gay couple. Now fast forward, the opinion wasn't clear enough. Now we have a graphic web designer, and the Supreme Court said, hey, you have the First Amendment right because of your religious freedom not to do a service that you don't want. In this case, an LGBTQ. But in the middle of it, to get standing, you have to have a plaintiff. You have to have somebody,
a character, in the story.
A character. Yeah, so a case in controversy, and the plaintiff that was involved, or the person in interest, was an individual named Stewart. After this case hit the papers, when the Supreme Court made this landmark ruling, Stewart said, "Wait a minute, I've been married 15 years. I wasn't the person, did not give you permission to use my name," and now everybody is scratching their heads because it appears the Supreme Court has heard a case that there was no jurisdiction in.
Right. Stewart is married to a woman. For
15 years.
Yes. Also, this case came with a lot of hypotheticals. So does that matter in this ruling?
Well, unfortunately, that ship is sailed. So now, you know, it's amazing how we talk about the ideology and the rights of LGBTQ versus other rights, but this was purely a First Amendment case, and Justice Gorsuch said it's an expressive case. You can't compel someone to do something that they don't believe in that violates their religious freedoms. Actually, he quoted George Orwell and said, if liberty means anything at all, it's the right to tell people what they don't want to hear.
Even this isn't based on fact.
Even if it's not based on fact, but you talk about a big battle between the 5th and 14th Amendment for LGBTQ rights. Justice Sotomayor, this is how upset she was. She rendered her dissent from the bench. Very rare in this 6-3 opinion. Gorsuch didn't back down, but at the end of the day, it's not really a ruling about LGBTQ rights. It's a ruling about religious freedom and First Amendment. But at the middle of it is Stewart.
And the whole credibility behind that
and the whole credibility behind it. So what pundits are saying is basically you had a legal PAC that was looking for a cause or a case, because Colorado is one of 20 states that have very strong anti-discrimination laws, and they wanted to be the first to challenge it. The problem is it appears they really didn't have a client. Wow.
All right, Greg, thank you. Such an interesting situation right now. If you have a legal question for Greg, by the way, you can reach out to him by emailing askisaacs@wate.com. And remember, we talk with Greg every Wednesday right here at 5:30 on WATE 6 on your side.